future hearing in the appeal of FirstPort Property Services against Settlers Court, RTM.
Ms. Ludlow, before you start, we will have a 2 minutes silent standing at 11 o'clock. At the moment, I'm not quite clear whether it will be announced on the tannoy, but if it isn't, I will announce it in due course.
My Lord, two housekeeping matters, if I can put it that way. The first is that overnight we've checked in respect to the regulations. We were asked to check that, and it's agreed that the regulations that were issued at the time of the legislation were in materially similar form.
Thank you.
One or two tweaks, but nothing that...
In the form that they now appear in the supplementary bundle?
Yes. The other matter is I've asked for Schedule 7.
Oh, I'm so sorry. Just on that, and were they issued at the same time as the Act came into force?
Yes.
As a package, yeah. Thank you.
But I guess if it's relied on for construction, the question is whether they were put before Parliament at the same time as the Act or not, was the bill. I guess whether they happen to be issued or come into force at the same time.
We haven't checked that through.
Well,
I'm not sure that is necessary.
It say on the front of them whether when they were laid before Parliament.
Yes, that's true.
My Lord, the other thing is that we've asked for Schedule 7 to the Act to be emailed through. In fact, I'll be referring to a case which it's the material provisions are referred to, but just for the sake of completeness, most of the parts of Schedule 7 were omitted from the bundle. Now I've got a complete set. My Lord, I'm going to deal with absurdity and obviously answer Lord Legate's questions in a moment. Before I deal with that, there are the issue here is primarily about the effects of dual responsibility for management, which obviously arises because although the effect of the Act, we say, and indeed Gala Unity says, is that the obligations under the leases of the flats within Settlers Court have the obligations of the landlord and the manco have effectively been replaced by those by the RTM company. That doesn't affect the obligations that the manco and or landlord have under the leases of flats at Sale Court and the other blocks, and indeed maybe under the freehold covenant. So one has this position where there's a dual responsibility for management, as it was described by Lord Justice Sullivan in Gala Unity, or shared responsibility. I think Lady Rose described it as yesterday. We have three more preliminary propositions before I get on to answering those questions about the anomalies. The first is that Parliament envisaged that agreements might be made between the parties to resolve dual responsibility for management problems. The most obvious of those is a Section 97(2) agreement. You've been referred to the provisions there. There are, however, other indications. There is, for example, in the model articles at clause 5F, and I mention this because I give you the references because I've not mentioned it in our written cases. In our written case, at 350 of the core bundle, where you'll see that there is a power to do such other things and to perform such other functions in relation to the premises or any leases of the whole or any of the premises as may be agreed from time to time with the landlord or landlords or any other parties to the leases as the case may be. So there's an indication there about agreements with the landlords. And indeed, in triple rows, Lady Justice Gloucester rejected the practical difficulties of dual responsibility for management, and she refers at, if you turn to page 588 of the core bundle, sorry, where are we? No, not 588. 584 of the bundle, and it's a little convoluted to find it, but if you turn to paragraph 54, about 2/3 of the way down on page 584, you'll see there's a sentence beginning, "Indeed, as Mr. Rainey pointed out." From a practical point of view, there will be nothing to prevent two or more RTM companies which were established in relation to separate blocks on the same estate from entering into an agreement to delegate management to one of the RTM companies, or indeed a third-party manager, to act on behalf of both or all. The articles explicitly provide for delegation. And then there's a footnote, and if you turn to that footnote at page 588, it's footnote 16, and it refers to the prescribed articles and said they can even appoint the landlord as agent. And those articles you have, but I don't think I need to refer you to them expressly. So there is yet another way that these matters can be resolved.
But section 97(2) and these articles give the RTM company the whip hand, as I understand it. Unless they agree, then no one can do, by way of management, anything which the RTM company is required or empowered to do under the lease by virtue of section 96.
They have the whip hand, but for something that I'm coming on to in a moment.
All right. But just tell me this.
Second preliminary.
Can you just help me on 97(2)? If the RTM company is required or empowered to do something under the lease by virtue of section 96, is it any answer to say that there's some other lease which empowers, as between the parties to that lease, somebody else to do that thing? I thought your submission was that because some other lease of a flat in another block contains a covenant by the landlord to do it, then that inevitably leads to joint management. But it rather looks at, in section 97(2), that unless the RTM company agrees, it doesn't lead to joint management, because if the RTM company has the right to do it, then the fact that the landlord's covenanted to somebody else in some other lease to do it doesn't mean to say he has a right to do so. He's got a statutory ban in section 97(2), unless, of course, the RTM company agrees.
My Lord, I would say that's not the effect of that, and and the reason for that is that section 97(2) has the words "to do under the lease by virtue of section 96." So it is something they're required or empowered to do under the lease, as opposed to something that they're empowered to do under another lease of another property in a different block.
Well, how does that work on the ground? Let's suppose that the lease of a flat within Block A, which is subject to an RTM notice, requires, one supposes, as it would do, the landlord to keep the exterior of the block in good condition. But suppose the lease of a flat in the next door block B also requires the landlord to keep in reasonable condition the exterior of all the blocks in the estate. Now, can the landlord say, "Ah, yes, but I've covenanted under a separate lease to maintain the exterior of block A, so even though you've served me an RTM notice, I can go on maintaining that exterior"?
My lord, yes, that is the position. And my lord, you may look surprised at that.
Well, I do, I must admit.
But the reason for that is that dual responsibility for management is not an uncommon feature in landlord and tenant.
No, but doesn't that undermine the whole thrust of this chapter, which is that Block A will only in future be managed by Block A's RTM landlord after the relevant procedures and notices have been given?
Unless there is some arrangement that is made otherwise.
Well, yeah, but I mean, but unless the RTM manager agrees.
But the obligation under the third-party leases at Sale Court and elsewhere still continue. And as I say, corresponding or dual obligations to manage and to carry out obligations under leases are very common. They not only occur where you have the splitting of a reversion, but they also occur within individual tiers of leases and head leases and subleases and underleases, where the freeholder may covenant to repair the roof as between the freeholder and the head lessee. The head lessee may enter into a corresponding obligation with the under lessee, and the under lessee may also enter into a corresponding obligation to repair the roof with the sub under lessee. And the fact that the sub under lessee has the same obligation, has an obligation to repair the same roof, is not very different from the position here. And of course, perhaps closer to the circumstances here is where you have a split reversion, which happens not uncommonly in this day and age, where individual blocks, the reversions of individual blocks, are sold off to investors, and yet the obligations to repair the communal areas of the estate remain on the individual freeholders or mancos for the individual blocks. So it happens. It's not an unusual feature of landlord and tenant law. And what we say is that that is what the effect of the legislation is. Now, if there was no means of the landlord to get out of that situation in such a way that it suffered a detriment, a disadvantage, or an anomaly as it's been described, then that would be, I would accept, that may well be considered an absurdity. But there are, in my submission, in the legislation itself, two ways in which that situation can be resolved. In our written case, we identified one of those, and Lady Rose took this up with my friend yesterday, put it to my friend yesterday, that there are provisions under the Act whereby the RTM company is plainly, if it doesn't provide the services, it's in breach of covenant, and that's enforceable in the county court under section 107 at page 336. The county court may, on the application of any person interested, make an order requiring a person who has failed to comply with a requirement imposed on him by or under or by virtue of any provision of this chapter to make good the default within such time as is specified in the order. So there's that one, which we have specifically referred to in our written case, and you heard my friend's argument, answer to that. Well, it wouldn't be practical because the RTM company lacks resources, but nevertheless, it's there as an option. But more importantly, the Act itself has a primary means for the landlord to deal with a failure in the relationship with the RTM company. And that is set out in Schedule 7, paragraph 8. And I don't need to take you to the legislation because the gauntlet was thrown down by my friend yesterday to identify how these matters could be resolved. And by that stage, the appellant had already answered it because they'd produced and relied on the case of Bentham versus Lindsay Court, which it is agreed by both parties explain the interrelationship between the 1987 Act and the 2002 Act. And if you turn to Bentham, which is at page 369 of the core bundle, and the relevant passage I'm going to read out is at page 375, from paragraphs 24 to 28. And I'm going to start at the second sentence of paragraph 24. The provisions of the 1987 Act relating to the appointment of a manager by the FTT were enacted when RTM companies had not yet been thought of. But RTM companies are not always successful, and the FTT may appoint a manager to take over from an RTM company, which is what happened here in 2014. Paragraph 8 of Schedule 7 to the 2002 Act makes amendments to the provisions of the 1987 Act so as to adapt it to the case where responsibility for management of the premises rests with an RTM company. It provides, for example, that to references to the landlord or to the RTM company and references to a tenant of a flat contained in the premises include a person who is a landlord under a lease of the whole or any part of the premises. That latter provision means that once an RTM co has acquired the right to manage, a landlord as well as a tenant can apply for the appointment of a manager under the 1987 Act. And the paragraph goes on. 5, the references to paragraph A1 of subsection 2 of section 24 to any obligation owed by the RTM company to the tenant under his tenancy include any obligations of the RTM company under this Act. That enables the landlord to enforce the RTM company's obligation to manage just as the tenants can. The following is particularly important. The power in section 24 to make an order appointing a manager to carry out functions includes a power in the circumstances specified in subsection 2 of that section to make an order that the right to manage the premises is to cease to be exercisable by the RTM company. And indeed, it goes on to explain that once a manager is appointed, it automatically leads to the ceasing of the RTM company's period of management. So we submit that it's difficult to see any other purpose for paragraph 8 of Schedule 7 other than to enable a landlord to enforce the RTM company's obligations.
But the trouble is they've got absolutely no incentive to do so. If you're right that section 97.2 does not preclude FirstPort from carrying out its obligations to maintain the common parts pursuant to its leases with other tenants in other blocks, then as Mr. Taylor says in his witness statement, great, they can cut their service charge by 20%. They just gather money to pay for the replacement of their own lift ropes and CCTV, and they just let FirstPort get on with maintaining it, and they don't have to pay for it. The difficulty is that, as far as they're concerned, this is very successful, because they're, as my Lord Legate said, they're sort of free riding on the work that's being done. So the landlord and the tenants of Settlers Court think this is working very well. It's the tenants of the other blocks.
My lady, if I can deal with that in two parts. The first is, and it doesn't bear on the construction point, but I would wish to say that is not the situation here. Because the position has been that there were negotiations for an estate management deed or shared services agreement which broke down. Now, both sides have a view as to why those negotiations broke down. But from the point of view of the RTM company, it took the view that the management company's suggestions were too onerous. And obviously, from the point of view of the management company, it took the view that the RTM company was not being generous enough. So one can understand that. So there was a genuine dispute about that. And what has happened since these proceedings, and as they were entitled to do in accordance with Gala Unity, when the landlord sent direct demands for payment to the individual leaseholders, they were entitled to say, we have no obligation to pay.
Well, that's the problem, isn't it? And so what's the solution?
The solution
if your clients can't or won't reach agreement?
My Lord, the solution is to use the machinery provided by paragraph 8 of Schedule 7.
And this is what Parliament had in mind, was it, when drafting this legislation, that you should turn to Schedule 7, paragraph 8 to find the answer?
My Lord, it's difficult.
That's what, has anybody done that in the entire time since this is there any evidence that this has been used?
I can't give that evidence. What I can do is...
Did it occur to your clients before the hearing?
My Lord, why would we advance to the other side a remedy that could be used against us?
Perhaps to show that there's a sensible interpretation of the Act rather than an absurd one.
Well, my Lord, that's the... in practical terms, we were not under no obligation to suggest that. But we need to look at the Act to see whether the anomaly arises under the terms of the Act. And what we say is that provision has no other explanation than to enable the landlord to enforce those covenants.
Or to enforce them, or to ask the court to direct a scheme that replaces the RTM arrangement entirely.
Well, my Lord, that is the big stick. If the and one should remember that this is we're not talking here about an expensive piece, necessarily an expensive piece of litigation. An application to appoint a manager under paragraph 8 in the first tier tribunal in England, or the Leasehold Valuation Tribunal in Wales, under which has limited cost shiftings powers, is not an expensive, necessarily an expensive thing to do.
So can you just explain who makes the application for what order?
The landlord makes the application.
Which landlord? Sorry, I don't know who you're talking about in this context.
The landlord as defined by the Act.
Yeah, who is that in this case?
This is the freeholder. Yes.
The freeholder?
Yes.
Of the Settlers Court block?
Yes.
But aren't the obligations owed to them anyway? Why do they have to use this mechanism?
My Lord, my Lady, the remedies are provided to the landlord because it is the landlord who is who has the main interest in ensuring that the entirety of Virginia Quay is properly managed, as opposed to one element or another.
But what interest has the freeholder of Settlers Court got in making an application to the court, provided the common parts of the estate are being kept up by FirstPort as they are?
Well,
It's not got the slightest interest in doing so.
my lord, they have every interest in ensuring that the estate is properly managed. And, my lord...
What happens if they don't feel like doing it?
Well, my lord, they have every interest in doing it. And this was provided, in my submission, it's obvious that the provision is there for that reason. But it's also, in case one needs to look at the consultation paper, the way that it's put in the consultation paper as well.
I'm so sorry, just before we move away from section 24, I had thought that that only operates in a case of fault. And here we're contemplating a situation where there is no fault because there is no breach of obligation. It's just that there's a gap, if you like, in the obligation network.
My lord, I did try in...
Yes, you said for cause or something like that.
Perhaps I can take you to the provisions.
Well, I think you said that you could use section 24 if, for example, a leasehold structure was inherently defective.
My lord, if I can take you to the provisions, because I wouldn't want to...
yes, it would assist me, thank you.
To use inexact terminology, if I can put it that way. Page 303. Section 24, as originally enacted, had simply a section 24A and a section 24B, and they steadily added lots of sub-paragraphs. So the original one was breach of obligation.
My lords, ladies and gentlemen, today is Armistice Day and it is approaching 11 o'clock. We ask all those in the building at this time to stop what they are doing and prepare to stand in a moment of remembrance for those who gave their lives in 2 world wars and subsequent conflicts. I will announce when the 2 minutes are over. It is 11 o'clock. It is 2 minutes past 11. Thank you for your mark of respect.
So please continue, Mr. Lockley.
Grateful.
Can I just have the page reference, please?
Sorry?
What page are we now on?
303.
Thank you very much.
There are, as I say, originally it was A and B. A, breach of obligation, plus it being just and convenient to make the order. AB, where unreasonable service charges have been made and just and convenient. ABA, where the tribunal is satisfied unreasonable variable administration charges have been made. AC, and this is a relevant breach of a relevant provision of a code of practice, such as the RICS Residential Service Charge Management Code, and it's just and convenient. But B is the catch-all, and B is the reason why it's not necessarily a fault, why it's court for cause, where the tribunal is satisfied that other circumstances exist which make it just and convenient for the order to be made.
But is it just if the effect of there being a gap in the matching between the obligation and the income is the result simply of application of the statutory scheme? Why aren't people just allowed to say, well, that's what Parliament has prescribed, it's just that should be the case? Well, no grounds for application under Section 24?
My Lord, no doubt on an application under Schedule 7, Paragraph 8, one of the matters that the tribunal would wish to know is what the offer that has been made by the company, by the RTM company, to pay sums to contribute to the overall relevant costs of the freeholder, of the manco or the landlord, is in any particular case.
The result of this order is that the RTM company that all the people in Settlers Court want to manage is sacked.
Yes.
And a new manager's put in, which is in exactly the same position vis-à-vis FirstPort as the one that's been sacked. So it doesn't solve the problem at all.
Sorry, no, it doesn't replace an RTM company with another RTM company.
It will be a scheme manager with such powers and authorities as the court gives it under the scheme, as the tribunal gives it under the scheme.
Exactly.
Yes.
And it could be for a very limited time. It could be for a single purpose, which is to deal with this particular issue.
And what happens if the freeholder doesn't act, but the freeholders or the tenants of all the other properties are the ones who are complaining because they're, at the moment, their manager of FirstPort is doing all the work and not getting any contributions?
Well, my Lord, there's no
remedy for that.
Third parties to apply. What we say is that it may not be a perfect way of enforcing the RTM's obligations, but that is what Parliament has laid down is the way to do it. And as I said I alluded to a moment ago, we say that it's difficult to see any other purpose to the rights under Paragraph 8 of Schedule 7. But if there is any doubt about that, and you've been referred to the consultation paper, it may well be some assistance to look at the way that it's dealt with in the consultation paper. And if you turn to sorry, I'm looking at the wrong one. Yes, I'm sorry. Page 699. I should say I haven't been able to check the bill, the terms of the draft bill that was accompanying this. But what it says at 95 is the main sanction against an RTM company which failed to carry out its management functions properly would be the appointment of a new replacement manager. Yeah. In addition to the existing grounds for the appointment of a manager under Part 2 of the Landlord and Tenant Act, it would also be possible to seek appointment on the grounds that the RTM company had failed to comply with any of the statutory duties imposed upon it by law, whereas the right can currently be exercised by any tenant of an affected flat. We intend that it should also be open to any landlord or the freeholder to bring an application where it was the RTM company that they were seeking to replace.
So that could be, if the landlord of Settlers Court was a different person from the landlord of the other blocks, could the landlord of this is intended to enable the landlord of the other blocks to bring this application, because the landlord of Settlers Court doesn't need this power because the obligations are owed to it by the RTM company anyway, aren't they?
Well, I suppose strictly speaking, we're talking here about the landlord of the common parts, aren't we? Of the estate. If we're right.
But I think you say, but you say, regardless of what's in paragraph 95 of the consultation paper, locus has not been given to the landlord of the estate parts to make an application under section 24 unless he happens to be landlord of the block which has been subject to the RTM process.
Yeah. But section 97(1) provides that the RTM company owes the obligations to the landlord as well as to the landlord under the lease. So that landlord doesn't need this paragraph 8 schedule 7 power, does it? Can just enforce the obligations.
Well, in practical terms, it makes no difference in this particular case because the freeholder is, as I understand it, the same in every instance.
Well, presumably you could, as the landlord of the particular block, say there's been a breach of the obligations owed to us under section 97 by the RTM company, and what's more, this is part of a pattern. We have no confidence that they're going to fulfil their obligations in the future. Please now replace them as manager of that block. Presumably is how it would work in relation to the block itself. Is that right?
Well, it seems to me that probably is right. But if I can just step back from this to say part of the issue of absurdity, it's not a counsel of perfection, and has to balance the effects of the absurdity, whether it's inconvenience or impossibility of performance, against the clarity of the legislation. And Parliament did, whether it's perfect or not, provide a mechanism for dealing with the absurdity, the legal absurdity, what we say amounts really to inconvenience, in this particular legislation, specific provision in the legislation.
And why would Parliament want to provide for multiple management of the same common parts in the first place?
Well, my lord, what we say is that the default position is that Parliament intended single management unless there was an agreement to the contrary. And that is, and in circumstances where there's dual responsibility for management, an agreement has to be reached.
All right, well, if you don't like the term management, why would Parliament want to provide for multiple responsibility for the same common parts? Presumably the problem gets compounded if each block appoints its own RTM manager. Then you've got 10 managers with concurrent responsibility for the common parts. Well, what's the logic of desiring that as the prima facie position? unless an agreement is reached or an application is made under this provision.
My Lord, the first point to make is that the default position is there should be single management by the RTM company. And it's a derogation from that. Parliament's allowed a derogation from that to arrive at the situation that your lordship envisages. But the second point is to...
I don't understand that. It's single management by
the RTM company.
But also by FirstPort in this case. Because under their leases, they're in the equivalent position.
My Lord, where there are other rights over the land, Parliament has therefore provided for the possibility of a derogation from the presumption that there should be a single manager. But one should also look at the flip side to that, which is that the alternative interpretation bakes in dual management in every single case. And it bakes in to any estate of this kind that there will always be two sets of service charge demands and that there will always be two lots of management.
But not two lots of management over the same structures and properties and bits and pieces.
My Lord, but in practice, as I've already explained, dual responsibility for management is something that is very common, and what happens is that's dealt with by agreements, whether in leases or in the case of this kind of arrangement, an estate management deed, or indeed the co-employment of the joint employment of the same contractor. That's another way to skin this particular cat, where one contractor is employed to manage the estate common parts, and the RTM company agrees to contribute a certain element of the cost, and another contractor and the Manco agrees to contribute another proportion of cost. But in every single case of there being an obligation to manage, in practice RTM companies and Mancos do not do the work themselves. They always employ a contractor. And why should that agent not be, as it was suggested in Triple Rose, the RTM company employing the landlord, or as we say in Section 97.3 agreement?
I'm having a little bit of difficulty of seeing the point you've just made, parties can agree, as being a solution to a problem with allocation of obligations under the statutory regime, because presumably the question of agreement will always take place against the backdrop of, well, what are our rights and obligations if we don't agree? So if there's a gap in the statutory regime and it suits someone not to agree and just rely on their rights, they won't agree, will they?
But, my Lord, it's in a sense, it's no different from the situation where if the RTM company decided not to employ a contractor to clean the common parts within the block. And in those circumstances, it would clearly be in breach of its obligation. When it comes to its obligations outside the block on the shared common parts, it will employ somebody else, whether a joint contractor or the landlord or the Manco, by some form of agreement to deliver those services, or indeed arrive at a section.
This isn't just on your analysis of Section 97.2 a common parts problem. If the leases in Block B contain a covenant by the landlord to maintain the appearance of the exterior of Block A, and Block A goes under an RTM scheme, I think you say there's still dual management even of the exterior of Block A, because you don't read 97.2 as taking away the landlord's entitlement to maintain the exterior of Block A if he gets that entitlement from a lease of a flat in Block B.
My Lord.
So you have, in a structure of that kind, you would have dual management not merely of the common parts, but of the very part, namely Block A, which it was the object of the RTM scheme to give sole management to the RTM company.
Lord, I've thought about that, and I think the answer to that is yes. And that may seem a very surprising answer.
Yes.
But there are circumstances where there is an agreement, instead of to maintain an individual block, but an agreement to maintain all of the blocks within an estate. That can occur. And so that would need to be catered for by way of an agreement, because if the landlord is under an indivisible obligation to do that, it would need to be catered for by an agreement. So I don't
You still get to the problem of getting the tenants in Block A to contribute towards the painting of the outside of their block, rather than saying, oh, lovely, yes, we like the outside of our block painted, and we're very happy for the tenants of Block B to pay for that, and you have to do it because of your obligation to the tenants of Block B, and we don't have to pay you anything towards that.
Well, my lady,
and your answer is, well, then the landlord can threaten to bring the whole regime crashing down by making an application under Section 24 of the 1987 Act.
My lady, yes, and not only the landlord, but so can individual lessees.
Of Block A.
Or Block A.
But not Block B.
No. But that's because it's the landlord who is the chosen, Parliament has chosen as the party, in effect, representing everybody outside the block.
But the argument against you is that the effect of 97.2 is to release, is quo-add the management responsibilities to which this chapter actually refers, which in the case against you is just the management of Block A. The landlord, if he has covenanted to the tenants of Block B to maintain the exterior of Block A, is to that extent released by statute from that covenant. So he can't be sued by the tenants of Block B for not maintaining the exterior of Block A. He can plead Section 97.2 and the RTM scheme, which has taken away that ability. That's the case against you, a rather more rigorous reading of 97.2. Well, at least I anticipate it's the case against you, though I'm not sure we've really heard from Mr. Allison about this aspect of absurdity.
Well, my lord, Mr. Allison threw down the gauntlet, if I can put it that way, and what I've said is that the Parliament has chosen the Landlord and Tenants Act of 1987 as the way of dealing with difficulties encountered in terms of arrangements made by the RTM company to pursue the management of either the block or indeed the communal areas of the estate.
Can I just ask, in relation to that, there have been a lot of criticisms, as you're well aware, of the Gala Unity case, so much so that the Law Commission has been carrying out its own work on reform. Has this potential solution to at least some of the problems that you're here putting forward, has this been discussed before? Is it in the Law Commission consultation paper as a way through these difficulties, or is it something that, as far as you're aware, you've discovered?
Well, my lord, it wasn't so much me discovering it, it was set out in the Bentham decision.
Okay, your interpretation of the Bentham decision, then?
Yes.
Is anybody else referring to that?
My lord, I can't say.
So it's not in the Law Commission consultation
Lord,
paper, as far as you're concerned?
I can't say. I just don't know.
Thank you very much.
Much more familiar with. Malone Jr., who's much more familiar with that, having been involved in some of the internal processes of this, doesn't believe it is.
Mark, doesn't it post-date the RTM consultation anyway? Case.
Yes.
It's 2020.
But in any event, as you probably heard that exchange, Bentham post-dated the consultation in any event.
Thank you. Well, anyway, Mr. Dudley, we've gone as deeply into that as I think we can within the confines of the time we're...
Yes, my lord, if I can move swiftly on.
Yes.
To the next anomaly, if I can deal with that fairly briefly. Apart from that, there was the suggestion that there was an overlap, section 73(4), an overlap between the, or potential of there being an overlap where you have multiple RTMs. What we say is that our primary argument that is resolved, because what we say is that the premises would be the blocks and the rights that pass would be the rights. And given that the qualification is of premises, there would be no overlap. There is a reference in both written arguments to the alternative position if it's Gala unity, which is the proper construction to the case of Pineview, which analyses this. And the reference, given the time, it's possibly not. There's probably not enough time to go into that. But it's at CV, it's the core bundle 519, paragraphs 60 to 61. And my friend says that's obiter. It's a matter for you as to whether you consider that's an appropriate analysis. Then it's said that this would be disadvantageous to lessees who could not who will be forced to acquire rather wider rights and obligations than they might wish to. Well, our simple answer to that is one takes the rough with the smooth. An RTM company, you cannot cherry pick it. If you undertake to carry out management obligations, you undertake to carry out management obligations. And we say those are the ones specified in the leases. And if you don't want to embark on that exercise, you don't exercise the right to manage. Finally, it's said there is a potential difficulty with reserves, and we say that is dealt with by section 94, which deals with the transfer of service charges upon the acquisition of the right to manage. In summary, when it comes to the anomalies, and I should say just a passing reference to the position of the interveners, my friend referred to Mr. Glenn's witness statement at page 147 of the bundle. You may wish to look at that.
Sorry, could you give me that page number again?
Page 147.
Thank you.
Bundle. The core bundle, paragraphs 34 to 36, I think it is, where some evidence is given of a survey. We it was described as second-hand hearsay. It is, insofar as it demonstrates anything. It tends to show that agreements are reached, although they're described as fragile. But nevertheless, in practical terms, it doesn't seem that there have been out there in the market, as far as the evidence produced by Armour, that it has proven to be an insuperable problem. They describe them as fragile agreements, but agreements are reached. And we suggest that it's not a counsel of perfection. Parliament has provided a mechanism for resolving the primary anomaly that has been identified, and one sets that against what we suggest is a fairly clear scheme based on my three propositions, the relationship between section 71, 72 and the transfer of function provisions, and that Parliament has then provided a means for resolving difficulties which might arise in the case of dual responsibility for management. And we say that for those reasons, it's not necessary to go beyond the words used in the statute. I should briefly mention, I've gone on far longer than I was going to.
Well, you had a lot of encouragement, Mr. Loveday.
My Lord, I should say that Corsan Fort does raise does have a walk-on part in the Gala Unity litigation. As you will have seen, it's on a different principle, but it was mentioned by the president of the upper tribunal after he'd become president of the upper tribunal, having been president of the lands tribunal. He referred back to it, but he referred to a different argument, rather curiously, perhaps, which was to do with a pertinent property and so on. And equally, the judge below, who is president of the first-tier tribunal, in that particular chamber, but sitting as a judge of the upper tribunal, also plainly read the Corsan Fort upper tribunal decision. For some reason, nobody at any stage, either below here or in Gala Unity, looked at the Court of Appeal in Corsan Fort, but there we are. And it's perhaps the way the appeals proceeded in Gala Unity that have set, we would say, this particular hair coursing, rather than had somebody at some stage gone back to the earlier parts of Corsan Fort, they may well have reached a conclusion on a different basis, we say, but there we are. In terms of the alternative constructions, we've had quite a lot of discussion about this already. And the first to do with the meaning of a pertinent property. And if I can just briefly say that what has been suggested is that one, by a process of statutory interpretation, includes words which stress that this is that the appurtenances must exclusively appertain to the premises. And then we have a number of cases to do primarily with the physical extent of appurtenances in other contexts. And in my submission, that elides two different considerations. There's a difference between exclusivity and physical proximity, if I can put it that way. And the cases go to physical proximity and indeed import the concept of curtilage. In terms of exclusivity, they don't help you reach those, none of those cases help reach the conclusion that it must exclusively appertain to the land, which is the basic point made in Gala Unity by the Court of Appeal. Interestingly, within this first alternative construction, it's not suggested that those 7 words refer, for example, to curtilage or to physical proximity at all. And we say one simply cannot import them into it. We have no quarrel with the list, with the authorities dealing with physical proximity in particular. But one must bear in mind that a pertinent property is defined in this Act, and it's defined in other Acts, and sometimes it's defined in other ways in other Acts. And one needs to construe a pertinent property within the context of this particular Act, this particular part of this Act. And in this particular Act, we are dealing with management rights. And therefore, it is, in my submission, logical to take it from that a pertinent property must include incorporeal rights, and if, and this is obviously on the Gala Unity analysis, that is dealt with within the, that is part of the premises consideration, that tells you something about the geographical extent of the rights that are transferred. What we say is that there are other pointers to, quite apart from anything else, if insofar as it's suggested that curtilage is a test within this first interpretation, one's in effect substituting another word of uncertain meaning for what it is suggested is a word that is already of uncertain meaning. No particular reason to use the word curtilage when it's not used in the statutory definition. One's replacing clarity with vagueness in my submission, and another tier of vagueness. And of course, I come back to the point that Parliament has not seen fit to provide any machinery to deal with the territorial extent of any rights that are transferred. That's simply absent. It's provided the backstop provision if something goes wrong, I've already indicated, but it's not provided any machinery to deal with what will be what may well arise on my friend's interpretation in every single right to manage case where there is a where there are shared common parts. There are a couple of small points made. There is in Schedule 6, paragraph 1, I'll give you the reference at page 342, a test for the disregard for non-residential parts. I simply refer you to the intervener's argument on this at paragraph 17, A to C.
I'm sorry, I think I got a wrong page number. Did you say 242?
342.
342.
Thank you.
The intervener makes a point on this at A to C at page 135 of the bundle, and I'd adopt that submission, their analysis of Schedule 6, paragraph 1. They go on to say something about common parts, which we say does not assist you because it's the definition of common parts that they rely on. There's a footnote on that page which explains that the definition of common parts that is referred to in the 2002 Act is different from their analysis. So one doesn't need to worry about the subsequent argument, but it's the earlier one. Also, the model articles at page 350 of the bundle, H, model article H, refers to powers to cultivate, maintain, landscape and plant any gardens, grounds or land comprised in the premises, which is inconsistent in my submission with a narrow interpretation of the premises, so as to exclude, rather more consistent with a wider interpretation. The second point I would deal with, the second alternative construction I would deal with very briefly indeed. In my submission, it simply doesn't work. The syntax simply doesn't work. But in any event, the sections 72(2) and 3 define self-contained buildings, and it would be surprising if 72(1) included a self-contained appurtenance when Parliament goes on immediately to only define self-contained buildings, or parts of buildings. And in any event, if one reads that together with section 112, one asks the question exactly what is a self-contained garden? Finally, there is the point that there is apparently, the alternative means of construction, apparently some agreement on the basis of our first proposition, but this is now on the basis that actually that's wrong and that the premises govern on the appellant's interpretation, that the premises govern the right, the geographical extent of the rights that are granted. We say it doesn't, but if we're wrong about that, then one needs to consider their alternative construction. And on this, they rely on Dartmouth Court, and perhaps that's a surprising result, because it might well be that the logical consequence of the third way of interpreting is that literally the right to manage is only acquired within the four walls of the building and nothing outside at all, no curtilage at all, if that's the way it applies. But even the appellant doesn't accepts that's not the case for the reasons given in Dartmouth Court. And so, in effect, we're getting back to the first argument that there is a curtilage. And I've already addressed you on that, on why in my submission it should not be limited by curtilage at all. So that's a brief canter through the Gala Unity alternative constructions. And what we say is that the answer to this appeal is, first of all, that the approach is that the rights granted under the Act are rights in relation to premises and not over premises, and that those can extend, and commonly do extend, to areas where there are corresponding obligations, third-party obligations to manage. That one looks at the leases. It has the advantage of simplicity, at least in that it's predictable in advance for one to be able to look at the leases, simply read the leases to understand the rights transferred, and that there are mechanisms to deal with any difficulties over the alleged absurdities that arise. We say it's therefore not necessary to go into the issue of the meaning of a pertinent premises, and it's perhaps not desirable to do so, because if we are right about the way that it works, the way the Act works, it's difficult to see that the definition of a pertinent premises is going to be terribly relevant in many cases at all, because one simply looks at what is disregarded for self-containment purposes. And we have a definition which in my submission speaks for itself without further interpretation for those purposes. But if you are against me on that, then broadly speaking, we adopt the Gala unity approach towards Section 72 for the reasons that I have explained. My Lords, I've gone on very long, and unless there's anything else, perhaps I could check with my learned junior. Yes. And I should just mention again, this is nothing to do with my submissions. I should have said that, in fact, what has happened in practice here is that the RTM company has demanded and collected service charges from the lessees of Settlers Court in respect of its obligations to manage the estate, and those monies are being held pending the outcome of this case. Either they have to be paid over to the management company in those circumstances, or they will be paid over to the management company following an agreement if the appeal fails.
Thank you. Thank you very much, Mr. Marley.
Could I just direct a question to both of you? Is there no commentary in relation to these matters that you think is worth us looking at? Clearly, we've got the Law Commission work, and it may be that you've taken the view that that is sufficient, but I see there's no other reference to Woodfall or any of these authorities. Are you confident that there's nothing that can help us in those commentaries? If there is anything, perhaps you could subsequently let us have it. Thank you.
Lord, I tried to include everything I thought was helpful.
Thank you.
Yes, Mr. Harrison. You probably bit into your full reply time with the length of your opening submissions. But,
My Lord, yes, I don't think I'll be terribly long.
No, good. But I would like to hear you on, for example, at some stage, Section 97(2).
Yes, of course.
In your own time.
Of course. What I was proposing to do is, so save in one respect, just reply on some points where I was itching to jump up and down, and now is my chance. Forgive me, I need to run through my notes and find the first point. So this related to discussion around Section 71, and you'll recall that one of the points the respondents refer to is the change in wording from what was Clause 53 to Section 71, and the relevance, they say, and they make the point, well, it's rights in relation to management rather than a right to manage. And there was discussion about why that might be. And our answer on that, to the extent it's helpful, is, well, because if you just describe it as right to manage, you don't have an all-encompassing right to manage the building. That's not what you're acquiring under the scheme. You are solely acquiring, and I think, to be fair, this is broadly what was being said, rights relating to the management functions. What you get under section 96 and 97 is what is listed there as management functions. And in fact, if you look at section 96, there's a power for the Secretary of State to change those management functions and add extra bits. But there are important rights relating to the management of a block that do not pass to an RTM company. This will be common ground between us. And if you look at sections 98 and section 100 of the 2002 Act, you can see some examples. On section 98...
What page?
Page 330, my lord. There's express provision relating to approvals, effectively grant of consent, things like that. Consent to alterations would be an example. Where there is a process where the landlord or the landlord continues to be involved. So that right in relation to management of the block is not wholly transferred. Another very important distinction is if one looks at section 100 over 2 pages, at page 332, and in particular you'll note the reference to the enforcement of untransferred tenant covenants, and at subsection 3, the RTM company may not exercise any function of re-entry or forfeiture. Now that might be pretty obvious because the RTM company is not acquiring the property, so it would be a bit odd if it could exercise the right of forfeiture, certainly if it was to revert to the RTM company. But the landlord continues with that aspect of managing the block. But it's not everything that transfers, it's the management functions that transfer. So that may well be a very good reason why the wording changes between clause 53 and section 51, because you don't get everything. You don't get a broad right to manage. You don't step into the shoes of the landlord. It's something different from that. There's a measure of agreement, I think, between the two of us, at least to that extent, on section 71. I then want to come on to a point that came up relating to section 72 and the qualification criteria. You may recall there was discussion about why is there that wording in section 72 that defines a self-contained building in the way that it does. So if we just turn back to section 72, at page 308, and I think, apologies, I can't remember who asked the question, but somebody asked the question, well, why does it need to be a self-contained building? Why does it need to be specified in this way? And the answer to why it's drafted in this way is that it imports the wording from the 93 Act in terms of enfranchisement. And that's because right to manage was viewed at the time the 2002 Act was being crafted, at the time the bill was being introduced, as a precursor to enfranchisement. The idea it would mirror the qualification criteria. So one could flow from RTM toward enfranchisement. So the idea was you'd have what was called an RTE company, a right to enfranchise company. And the easiest place for you to find anything on that in this bundle is at page 462. It's within the Fencott case that we looked at yesterday, and it's paragraph 36.
Well, that's a recitation of Mr. Rainey's submission, isn't it?
It is.
Is it?
I don't think
Can we find elsewhere that the court says that's right? Mr. Rainey's not always right.
No, Mr. Rainey's not always right.
It's my head of change as he is.
We can continue the debate later. But no, I think he is right about this. 62 to 64. So that's page 468, bottom of page 468.
Right, but of little assistance.
Well, my lord, I'm filling in an answer that came up yesterday.
Yeah.
Why is it crafted in that way? I have no further submission as to where that may lead anyone, but I wanted to fill in the gap as to why the Act is drawn in that way, and no more. We then moved on to section 96(1) and this question of what does in relation to, and Lord Briggs gave an example of a holiday development, and then we came on to, well, what about mooring rights? Would those be rights that they're in relation to? Because we were trying to work out, my learned friend has to come up with something that conceivably isn't a right in relation to the premises, because otherwise section 96(1) has no purpose. And that was the discussion yesterday. It was an example of obligations to maintain the adjacent holiday park and an example of mooring rights.
Well, it's the insurance obligation may be more fruitful for something if there's an obligation on the landlord to insure something that might not be related to the premises.
Well, my lady, on the assumption that the covenant was to insure land over which there are rights that the leaseholders enjoy, as I understand it, on my own friend's argument, that would be a right in relation to the premises, and that's because the management functions expressly include insurance. And it's pretty difficult to envisage a lease obligation to insure something that the leaseholders don't enjoy, that the leaseholders nonetheless have to pay for. It's conceivable, but it's commercially extraordinary. But on mooring rights, I mean, this is a good example because we have here a development along the River Thames. There are rights to walk alongside the edge of the Thames, and indeed the estate includes the river wall. Why is the line drawn there rather than if there's moorings next to that river wall that there were rights over, the rights to use? Why is that not a right in relation to if it's a right that's granted under the lease of your property? I mean, this is very common. There's lots of developments around the coast where a flat comes with a mooring. And the costs of maintaining the moorings are a service charge. They form part of the estate service charge. It's very common. Why is that not another form of estate charge? Why is that not a right in relation to premises on my learned friend's construction? I still say there aren't actually any principled points where you draw the line. If he's right, and there is conceivably something under section 96(1) that isn't something in relation to the premises, then you've got to draw a line. And if you've got to draw a line on his analysis, I agree you've got to draw a line on my analysis, and you're still left with the same problem of there's no mechanism by which you determine where the line is drawn. So it's a neutral point. We then came on to that point about there not being any resolution mechanism, and the difficulty with not having a way for the tribunal to sort things out. And my other friend's answer was, well, there is a mechanism for resolving costs, because to the extent a party incurs costs unreasonably, they can be determined, but that there isn't one for resolving which obligations pass. But there is a process for determining which obligations pass, because if someone isn't performing their obligations, you can, under section 107, go to the court or the tribunal and ask them to enforce the obligations. And if you're asking a court to determine obligations, it has to work out what those obligations are. The only mechanism that's missing is any way of forcing, in this situation, the RTM company to pay money to the manager in respect of dual management. And the other way round. If the RTM company was managing everything and my client wasn't paying, they have no way of enforcing it. That's the only missing mechanism. So then we came on to this nexus requirement that my friend accepts is unlikely to be encountered commonly. This is, trying to work out where that line is for section 96(1) purposes. He accepts that would be a rare situation. But he said, well, by contrast, if you've got to determine the rights that a company writes outside the 4 elevations of the block, that's an issue that will arise on every single occasion the right to manage is exercised. And as to that, I say that's wrong. And the very obvious example is anywhere where the right to manage is acquired over a block that doesn't sit on an estate, which is the situation in most of the time when the right to manage is exercised. It's a single block. Landlord doesn't own any other land. There's no estate common parts. It's just a block sitting on a plot. It's not just the 4 walls, though, because there might be parking around it for the people on the block. There might be gardens. They're all exclusively enjoyed by that block. No one ever suggests, nor could they sensibly suggest, that you only get the 4 walls and you don't get the gardens and the parking, because it all comes with it. It's all a block cost. There isn't an estate cost, because there isn't an estate, there's no shared. So it's only an issue that comes up with multi-block estates. Or could be a block with lots of houses around it, but it only comes up where there's areas that are shared between multiple parties. And that's actually not that common. The vast majority of RTM cases, it's a converted mansion block or something. It's or a single block. So it isn't every single occasion. It's just on multi-block occasions that you've got to draw the line. I accept to that point, you've got to work out the answer. We came onto those prescribed forms and the difficulties that were pointed to in those notes on the back, and it was a bit unsatisfactory, and I agree. It's a bit unsatisfactory on those notes that they don't make a bit clearer that you're only getting the right to manage in respect to the block and not the wider estate, and it just says everything that was your landlord is now the RTM company. I agree that those notes are unsatisfactory. I don't say anything turns on it. It's implicit that the premise is as specified over leaf, i.e. it's the block. I think lawyers would understand what it means. To the extent it's an explanatory note that's intended to be read by a layperson, it's pretty unsatisfactory. That's a matter for Parliament. But the original note, we've checked, the 2003 regulations were laid before Parliament on the 11th of August 2003, so well after the Act. Before the Act came into force, but only by a few weeks. And you'll find that printed on the front of the 2003 regulations. I'm not sure that those have been submitted, so we'll email those in to hand them up. We then got onto the point about dual management. Was today. And my learned friend's point is to say, well, actually, dual management is very common. It's not just in the RTM situation, it happens in other situations. The first example he gives is head leases and subleases, where there are obligations under the head lease to maintain, the head lessee covenants with the freeholder will maintain all of the blocks, and then you might have a sublease of each individual block, and so on and so forth. So we have a chain of covenants. That is not an example of dual management. That is an example of dual obligations. Because what we have is everyone effectively is subcontracting down the line their obligations, and they can all enforce as between themselves. And if the party at the bottom fails, it can come back up the chain. But effectively, you have a chain of indemnity. You do not have that in an RTM situation. The other point is, you only have one person paying for it, because it's going down the line. It ultimately ends up with all the separate leaseholders, and then it comes back up the chain. So it's a sort of subcontracting situation. It cannot possibly result in dispute. It's not dual management in the same way. The second example is where the reversion gets split. And I imagine what's envisaged there is where the reversion is sold after the event. So here we have the whole of Virginia Key is owned by a single landlord, but that landlord could sell Settlers Court to the RTM company. And they'd have to work out where the bounds of where the bounds are. They'd have to draw a line, but they could sell it and there'd be a split in the reversion. That's fine. But the answer to the answer to whether that produces dual management is the parties there have to agree to a sale of the land or to a sale of the common parts or the estate roads, whatever it is. They have to agree. Because if they don't, they're not going to be able to comply. The incumbent landlord can't comply with his covenants to maintain the whole because he won't own the whole and he won't therefore be able to go onto the land and do it. So the answer is, in every situation where that occurs, contained within the transfer of part are mutual covenants. There's an indemnity from one to the other. There's a covenant to comply with the obligations as regards the land that has been sold, and an indemnity to the extent that they fail to do so. Very different from RTM, because in RTM, it's automatic. The landlord doesn't get to negotiate over how it's going to work, it just happens. And my lawyer friend's answer is to say, well, you must just reach agreements. You negotiate and you reach agreement. But how does FirstPort negotiate with the right to manage company? It cannot give up control to the RTM company because nobody else on the estate has agreed to the RTM company doing things their way. They might want to spend less on the gardening. They might want to only clean once a week rather than twice a week. Whatever it is, there are management decisions to be made. FirstPort's obligations are to its leaseholders. Sorry, to the leaseholders on the estate in respect to which it still has management obligations. So how does it make concessions? How can they agree anything other than the RTM company must pay over the share that its leaseholders would otherwise have had to pay? I mean, fine, there are certain things you could agree to consult and things like that. But what you can't agree to is something like, well, we'll pay you the amount that we think is fair once you've done it. It's a common suggestion. It just doesn't work. You can't do it. Nor can you say, we'll pass over control of this bit to you. The bit closest to you we'll let you manage, and then we'll manage that bit and we'll work out the costs afterwards, because you still owe those obligations. You can't do it, at least not safely. And you also can't agree a chain of indemnity because the RTM company has no assets. What's the point in a chain of indemnity? So that's the problem with saying you should just agree. So the next answer is to say, well, there's Bentham, you can apply to appoint a manager. And that was the solution I was trying to find out. What was being suggested is the answer to these absurdities. It might be a doomsday option if this appeal doesn't succeed, I agree. You still have to prove cause, and there are the difficulties with that that Lord Sales was referring to. Because Gala and the respondents will say, well, we don't have to pay, so on what basis do you say that there's some failure? But fine, the tribunal might be pragmatic about it and say, look, this is unworkable, a manager should be appointed. But at that point, the RTM will come to an end. How does that help the right to manage company? And what is the manager going to manage? It can't be that it's going to manage the estate, because then that would be in place of FirstPort. The landlord would have to apply to replace FirstPort in respect of the estate. Well, that's just completely illogical as a solution to this appeal. So instead, they would perhaps just order the manager to manage the block. FirstPort carries on demanding the estate charges. Okay, maybe that's a solution, but the problem is then you've got a manager managing Settlers Court in place of the RTM company in circumstances where ordinarily, if an RTM fails, it would revert back to FirstPort. So why does FirstPort lose out. It's still illogical. The greater difficulty is it is not a solution, because a court-appointed manager is not appointed forevermore, and that's because the court has to oversee the process. The manager might be appointed for 2 years, 3 years, 5 years, but it's not intended as an indefinite solution. It's an interim solution to sort out a problem. So the answer is the manager, maybe a slightly ridiculous solution is you appoint a manager for a day, and then as soon as the management ends, everything reverts back to how it was. But you've got to wonder whether this could seriously have been intended by Parliament as a solution.
Well, it's only open, as I understood it anyway, to the landlord of Settlers Court.
Well, that's the greater difficulty.
That might be the tenants. They might have acquired the freehold, or it might have been sold off.
Yeah.
And the person might have no interest the landlord may have no interest in stepping in. Why would they?
Well, they wouldn't in this situation, because so far as the landlord's reversionary interest is concerned, everything is fine. Everything's being managed. Now, what my learned friend said is, well, there's no other purpose to that provision in Schedule 7 that you were taking to that imports or alters the 1987 Act. And I say that that's obviously not right. If the purpose is, if the RTM company fails in its obligations to manage Settlers Court, the landlord considers that its reversionary interest is at risk, the landlord will apply to the tribunal to get a manager appointed. And that is a very common situation. I can give you 2 examples. One is they need to carry out works to a roof that's leaking and they can't get the money together, and the landlord has serious concerns about damage to the building, or it's resulting in the insurance perhaps being invalidated. That's going to impact on the landlord's reversionary interest, and the landlord might want to step in. On a more topical note, and this is coming up all the time, is with the current costs of fire safety works, replacing cladding, putting fire marshals into buildings, so on and so forth. Again, the right to manage company is going to find it very difficult, for a very good reason, which is that the leaseholders themselves will find it very difficult to find the money to pay for that. But the freeholder is under statutory obligations to ensure that the building is remediated. So the landlord has 2 options. One is sit back, wait and wait and wait, and see what the RTM company does and hope it doesn't become subject to any statutory enforcement and hope nothing happens, or step in. You can wait and wait and wait until the RTM company becomes insolvent, because once the RTM company becomes insolvent, the RTM automatically ends and it reverts back to the landlord, or in this case, the manager. But your alternative is you're proactive and you go to the tribunal and you apply. And if you look at Section 105, subsection 4 of the Act, that provides for one of the examples of where the right to manage will automatically cease, and that includes where a manager is appointed. I have to confess, I was a little surprised when I had another look last night at these provisions not to find that FirstPort can apply, but it doesn't. And that suggests that my learned friend solution is wrong. If I can turn to the Section 97.2 problem, I think the example was given well where the Block B leases require the landlord to maintain Block A even after the right to manage.
Maintain the exterior of it.
Maintain the exterior.
Yeah.
I mean, that may seem like an unusual situation, but what is perhaps a more common situation is where the right to manage is exercised over part of a building. You have one big mansion block and one half exercises the right to manage. That's a fairly typical situation. And of course, the covenants will have been in respect of the whole of the building. How would the right to manage work unless the right to manage company takes over without the involvement of the landlord? It can't be that in that situation where you exercise right to manage in respect of the left half, that the landlord carries on being responsible for the whole. It cannot make sense because it would render the right to manage pretty worthless, frankly. So instead, the landlord's released from their covenants under section 97.2 in respect to the half that exercises right to manage, and the landlord carries on managing the retained half. That does cause complications in certain leases because if the apportionment is a fixed percentage, the landlord's left not able to recover any more than half of his expenditure. But the solution to that is you have to apply to the tribunal to vary the leases with effect from the date the right to manage was acquired. So it's a bit of a nuisance, and it's a bit of a failing in the scheme of right to manage that it doesn't deal with that, but it does happen and it gets resolved. That's how section 97.2 operates. And
so you say 97.2 does operate to relieve, on a statutory basis, to relieve the landlord of a covenanted obligation to someone else to do that which the RTM company is statutorily authorised to do.
Yes. Yeah. I mean, I would suggest, with respect to Parliament, it could have been better expressed.
Yes.
By expressly saying you're released from the covenant rather than just say you can't do it, but you're nonetheless obliged, which is how someone will no doubt try to argue it one day. But yes, that's not how it is.
But you say, well, that's going to be quite rare if the only obligations which are transferred are limited to those within the self-contained building or other things which are exclusively used by the tenants of that building.
Lady, yes, but the example I give of the right to manage being exercised in respect of half of a block, a self-contained part of a block, it's inescapable that that's going to be engaged, I would think, because usually the block will be maintained as a whole rather than in two halves. And it's not certainly I've come across it in practice. I don't have any numbers on it, but it's a situation that arises at least.
So you do say that in this case, if Mr. Loveday is right in saying that the RTM company for Block A acquires under the Act the right to manage the estate parts, that would release the landlord from his obligation in relation to the estate to all the other tenants. And that's such a monstrous outcome, it can't possibly be the right construction.
My Lord, I do, but I do accept in our written submissions that given the absurdity that produces, if the answer is that it must be across the estate, then we must have to read section 97.2 differently. And my learned friend's solution to that, to say that you read it as it's only the obligations under the leases of the premises that are released, must be the answer, because otherwise the absurdities are overwhelming. And it's not a hugely strained reading of section 97.2 that my learned friend suggests, and indeed I've seen it adopted on other occasions. I don't suggest that my learned friend's alternative way of reading section 97.2 is a monstrous way of dealing with it, but it isn't how it most obviously reads. But if it is to be read in its literal sense, if it isn't to be read as effectively releasing the landlord or the manager from their covenants, that will create difficulties. So it is a problem to be grappled with one way or the other. I think one of the last points that was made by the film was just going back to this point about how one reads section 112, and I think it was suggested again that we say you need to add words to make clear what that the appurtenance is exclusively appertain to the premises. I did emphasise this yesterday, but just to be clear, I don't say you need to add words. I say you need to understand what appurtenances are.
This is your primary point.
Lady, yes.
But looking back last night at your written submissions, I'm looking at paragraph 52 at page 91 of the bundle. You said there that your primary case was that the appurtenant property included is only that which is both within the curtilage of the building and exclusively used and enjoyed. But I had understood that your answer to my Lord Burrows yesterday as regards the gym, which is some way away but is still exclusively used by the leaseholders, would be included in the premises.
Well, Lady,
Did I
yes.
misunderstand, or have you changed?
No, you didn't misunderstand. I think my argument has developed slightly, but I did want to come back on that gym point. And just to be clear, of course, this point doesn't arise on the alternative construction being the one that we all agree on, that we focus on 96.1, but it does arise on the Gala line of thinking. So the simple answer to Lord Burrows' point on the gym, it would be to proceed on our alternative construction, on my learned friend's construction, and say we're just dealing with in relation to, and then we say on the gym, well, the gym are premises in relation to the block, because we're reading in relation to in the sense of being exclusively enjoyed with. It is an extreme example. We all have to accept that it's exclusively enjoyed by the block, but it's half a kilometre away. But that would accord with the alternative case. But then going back to our primary case, it's also worth noting that where we're having to consider what are the premises in section 72(1)(a), and then we're thinking about section 112, I go back to this point that the definition of a pertinent always bends to the context. And I took you yesterday to Matthew and Campbell, and then to Dartmouth Court, where an alternative approach was taken on that. And a further example then touches on the curtilage point, is a case called McGurk that you find at page 384.
But you do seem to be using a pertinence then. If you say that a pertinent property does not have to be within the curtilage, but it does have to be exclusively enjoyed by the tenants, you are using the word to mean something rather different from what any of the cases say it means. And you get round that by saying, well, you have to bend it to the context according to Dartmouth.
Absolutely, and that's why I'm taking you to McGurk as an example of that. And it may be that the conclusion you reach from all of these cases is that all that you can tell about appurtenance is it bends to the particular context. But that's why I want to take you to McGurk. This was a case where there was a lease of the flat. It's an enfranchisement case. And there was a lease of the flat.
Which page are we looking at? Sorry.
Page 384, my lady. That's a lease extension. There's a lease of a flat and a separate lease of a storeroom that was outside the flat, so outside the demise, and not within the curtilage of the flat. So there's a storeroom. I think it's on another floor, but it's within the block. It's a lease extension on section 42 of the 93 Act in respect of both the flat and the storeroom. And the storeroom was found to be an appurtenance within the meaning of section 62(2) of the 93 Act, despite not being within the curtilage of the flat. And in that case, in the context of that scheme, it sufficed it was within the curtilage of the block in the context of that statutory scheme. So it's another example of the understanding of appurtenances and the limits of curtilage bending to meet the statutory scheme. If I can just take you to one passage, and it's page 392. And I'm looking at the paragraph that starts by the letter D.